Good afternoon, everybody. Hope you're having a wonderful day. You may be wondering why I'm wearing this mask. Well, if you've actually seen my face live, you would know because I'm kind of ugly, but I will take it off. The other reason I'm wearing it is because I want to offer it up. Yes, indeed, you lucky you. We're giving these away. So just contact Tammy at her email address, and we'll send you one right away. It's double layer, so it's extra safe and it's adjustable. So what a great deal. So if you get nothing more out of this presentation than that, at least you've got that to go. All right, let's get going. Oh, one other thing we should mention. There's Louis Laris. He handles our written recon department. If you've got a writ or recon that you need to have it be addressed, please let him know. He's done hundreds of writs of review, dozens of Supreme Court petitions for review. He's appeared in front of most of the DCAs and the Supreme Court. So quite a qualified individual. But let's get on to the topic at hand. Home-based work is nothing new, and it's never going to go away. I really don't think it's ever going away. It's the quote-unquote new normal, which seems to be the phrase that pays as of late. Even with the vaccine, experts are predicting that people are going to continue to work from home, and that makes a lot of sense. Number one, we all kind of like doing it if we get some time away, and we'll talk more about that later. If we're not trapped in our home, there are some advantages, and I know a lot of you were previously working from home even before COVID, and it leaves us less of a imprint, a real estate imprint for the employer. They need to rent less space or buy less space, so there's a great money saving component to that. As I say here, 55 execs believe that most employees will continue to work remotely at least one day a week. Here's some interesting statistics. I thought if you see few executives think company culture will survive a purely remote working setup, but note the word purely. They do seem to think that remote's going to go work. The primary one, 29%, 3 days a week. They think that their employees should be at the job site 3 days a week and at home or elsewhere 2 days a week. That means 40% of the time, all things being equal, injuries are going to be home-based. So good reason for us to investigate that. First, we should note that working at home is not always the easiest thing for folks because they are kind of stuck, and it can be frustrating and depressing. So make sure your employees are familiar with your EAP. You may have had one for a long time and people aren't necessarily aware of it. Encourage its use and remind them. I know we've had this at Bradford Barthel that there's no stigma attached to it, and it's private. So there's no reason they shouldn't take advantage of if they're feeling down and out as a result of Corona and being stuck at home or for any reason. All right, safe telecommuting practices. There's a whole host of things we should be doing affirmatively, not passively, for both the safety of our employees and the safety of our pocketbook when it comes to workers' compensation claims. We need to create a workplace policy in writing about expectations for telecommuters, home-based folks, which needs to be reviewed with the employees and need to have them sign an acknowledgement, because that may very well be Exhibit A or Exhibit 1 in our workers' compensation trial or points and authorities. Setting fixed times, work hours, meal times, rest times, does a couple of things. It also helps to defend claims, and it keeps things, it helps define the course of employment, so it definitely helps to defend claims. We want to define clearly their scope of work. We want a policy that affirmatively says what their job is, and more importantly, what their job isn't. And we're going to go into reasons for that in short order. Identifying home office standards and what is excluded from home office standards, that which they should not be doing. We want to provide training. I know this is starting to sound expensive, but an ounce of prevention is worth a pound of cure, they say, and there's a reason they say that. Workstation setup. I'll bet you a nickel that if you haven't had somebody professionally check, that most of your employees have ergonomically incorrect setup workstations at home. Safety measures need to be reviewed, and ergonomic best measures or best practices should be reviewed. And again, they should be signing off that they've received that being used by the injured or by the employee before they become an injured worker, so that when they get injured working with that power saw or that power drill, we can demonstrate that that should not be considered work related. We want to enact guidelines for check-in, so we know when they can, when they are on the clock, and when they're off the clock. Hopefully, you've got a time clock equivalent on their computers. Geo-tracking. I'm often asked about geo-tracking. Can we track them on their phones or on their computers or what have you? Similarly, equipment tracking is somewhat related. Very dangerous to do. Lots of laws, lots of case law. Do not engage in this unless and until you have talked to a lawyer about the specifics of your particular situation. Fraught with peril. Do not do this on your own. We want to encourage their mental health. We talked about the EAP, but we also want to get them to showering. I mean, it's so easy not to shower or not to dress, just to stay in your sweats. That's terrible for our mental health. We want to encourage them to take care of their mind and their body. Hydrating. A reminder, a memo to that effect is always helpful. I know we have water bottles and mugs for our employees, and along with the reminder. Exercise, even recommending exercise clubs or remote clubs or virtual exercise clubs with amongst employees. I know we've got some people who you do the Just Dance video game and to keep in shape. Keeping them social. Social distancing does not mean no socializing. We need to underscore that they need to be interacting with people. I know I'm harping on this. I'm concerned about the folks that are getting depressed, because the people that are getting depressed are the ones that get injured physically and emotionally, and we get those workers' compensation claims. How else should we maintain their mental health? Get them outside regularly and encourage them to do so. And pamphlets and meetings are a great opportunity, say monthly meetings with employees, even if it is telephonic or through a Zoom more likely, are great opportunities to do something exactly like that. Also, don't encourage, require that they take breaks. There's a good reason for that. It's first off, we want to give them the opportunity to split up work projects. Psych studies demonstrate that if we break up the projects, it's less stressful. I know I'm the kind of person who likes to say, okay, I'm just going to work on this project until it's done. Hunger and everything else be darned. I'm going to finish it. I'm not going to take a break. That's exactly the way it shouldn't be done. Let's face it, California and most states mandate, for at least for hourly workers, a 10-minute break every 3.5 hours and a 30-minute lunch break. There's good reason for that. It's not just because the unions have argued for it, although of course they have, but it's a good mental break, and it definitely will help avoid the psych claims. And like I say, if a depressed person is more likely to be injured. Taking ergonomics very seriously. This I know is an expense, but something that should be at least considered, and that is having a specialist visit the home. You can imagine somebody saying, I got carpal tunnel for typing too much, and nobody taught me how to set up my desk, and I was typing in an ergonomically incorrect way, says the PTP or QME now. Not going to be very helpful for our defense of our case. Also, when identifying the workplace, sometimes the work spot, and we want to identify the exact place where they're going to be performing their work services or work duties. We have to consider whether there are additional spots. There's always a chance that the primary place, the primary desk, the primary chair, the primary computer that they're going to be relying on, are sometimes taken over by the spouse or the kids or what have you, and that there are alternative places. These need to be identified, and a home office safety check needs to be drafted as long as and signed. Not just ergonomics. We also have to make sure that they've checked and addressed any problems with fire alarms, surge protectors, frayed wires. We want those surge protectors not just for their physical protection, but also for the protection of your data or your computers, because I presume they're not using their personal computers. And cybersecurity, we shouldn't have to discuss that. If you don't have cybersecurity, you're going to have a whole host of problems. Again, we talked about regularly scheduled staff meetings. We have ours monthly here at Bradford Barthel, addressing again the EAPs. Telehealth options, we have that. We want to underscore that's available to our employees so that they know that if they're injured or have a problem, they can go to a doctor in a non-industrial setting and have it taken care of. If they think if they don't believe they have any medical options other than file a workers' compensation claim, I guarantee they're going to file a workers' compensation claim. Suicide hotlines information should be circulated, as well as AA contact information. Now, I am not talking about applicants' attorney contact information. I am not, I promise. I'm talking about Alcoholics Anonymous and various other California hotlines, too numerous to mention. Okay, easy question. Can injuries occurring at a home office be work-related? Sadly, often yes, but not always. Any defenses? Absolutely, good news. But the general rule is the employment relationship can be, in fact, it is the express rule, black and white, employment relationship can, under certain circumstances, extend to the employee's home. The primary consideration is that work contemplated by the employment, whether it's written, it's oral, or it's implied by the actions of the parties. Who cares? You care, because as I suggested earlier, you can limit the relationship. That is, you can limit the work relationship by express decree that should be signed off by the applicant to the time and location of their work duties. Okay, let me underscore that now. We can limit the employee-employer relationship to certain areas and certain times, as long as we've done that in writing, so that when the injury occurs elsewhere, in the backyard, in the front yard, in the bedroom, where I'm assuming there is no office, we can fight the workers' compensation claim. We want to require, again, in writing, that all work be done in the workplace, because if it's not, the workplace can be expanded, and we know about that through special errands, special missions, and work at home. Okay, work that's required to be performed at the applicant's home or at the worker's home. Well, the going and coming rule does not apply. So if they are working from home and they're doing some work at the office, going back and forth, we cannot use the going and coming rule, the rule that bars workers' compensation claims when the injured worker is traveling from home or wherever it is they choose to travel to be to the office, and then back from the office or place of employment to where it is they choose to be. That's a general rule. Lots of exceptions. The big one here is if they're going from workplace to workplace, and if it doesn't apply, and if the home has an office, we're gonna have a big problem trying to use the going and coming rule defense. All is not lost. First off, a lot of employees who claim to that they're working from home that the work that they do perform from home represents a work job site. A lot of times they're just dead wrong. And if they're dead wrong, they can't overcome the going and coming rule. And we've got some examples of that. So absent the employer's direction to work at home, an employee who consistently works at home, even with the employer's knowledge, is not working at home as a second work site. And we've got some case law directly on point. There's got the Wilson case. We had a teacher who was in a motor vehicle accident traveling to school. So defense is even going to say going and coming rule denied. And the employee said, no, going and coming rule is not going to work here because, and they said, quote, exceptional circumstances were established by her performing work at home the night before the accident and by transporting work-related items to class. By the way, I've seen situations where defense attorneys and applicants attorneys have put files on every day in the back of their trunk so that they can try to claim that anything that happened in the car was work-related. They've been unsuccessful. So let's see with this teacher, was she successful? Well, it turns out, nope, according to the California Supreme Court, she was not. The home was not a second job site, and therefore the going and coming rule did indeed apply, and she lost. What was the reasoning? The only place she was required to show up was at school. She wasn't required to go home. She wasn't required to, she could live anywhere she wanted. And the location of her home was none of the employer's business. That was her doing. There's no implicit, explicit, or contractual agreement or requirement that she work at home. She did it because she wanted to. It was for her own personal convenience. And that's the magic words, personal convenience. Similarly, we went from grade school to a college professor. This professor was killed on the way home from work. Every time I hear that there's a work-related death, I start to squirm and think, oh boy, the judge is going to do everything in their power to find injury AOE COE because it's just too sympathetic a case. The spouse argued, hey, he often worked from home. In fact, that's what everybody did. All the instructors, all the professors worked from home. Everybody knew about it. Nevertheless, it was held to be barred by the accident was held to be barred by the going and coming rule. It was not a work-related injury. Again, the California Supreme Court weighed in and said, unless the employer requires the employee to work at home as a condition of employment, requires and condition of employment, some more magic words, the fact that you just happen to work from home all the time does not make the home or any other place, Starbucks or wherever it is you do your work, does not mean the going and coming rule doesn't apply. Quote, a home does not become a second job site, nor again Starbucks or wherever, simply because one's employment requires long working hours and the employer knows the employee frequently brings work home, Starbucks, the library, where have you. The library, that is, if it's not the school's library. The court found no evidence that, quote, faculty members were required, implicitly or expressly or otherwise, to work from home rather than on campus. So other courts, not just the California Supreme Court, although that's pretty good. That's a pretty good level of authority. Other courts have also weighed in. In the Harmon case back in '87, we had an employer or employee who worked at home but said, oh, it's more efficient, or worked at school, but it was more efficient, quote unquote, at home. The argument basically being, I'm providing a benefit to the employer by being a better employee by doing my work from home, which is a good argument, but it didn't win the day. And they said there was no, again, you should be able to tell me what they said, that there was no indication that the job site at home was an implied condition of the job, was required expressly, implicitly, or contractually. So no go. More recently, 2018, we've got a slightly different fact pattern. They were returning to work from an uncompensated lunch break at home. Well, okay. Well, we know the personal comfort doctrine suggests that if you're having your lunch at the office, and slip and fall on the banana peel, that it's going to be work related. Yes, bad news. It really is probably going to be work related. But in this situation, they actually left the businesses, the place of work's location, and went home. And the question was, and once again, a death case. So once again, I start to get nervous. It was held, hallelujah, not to be compensable because, once again, not required. There's that magic word, required, to work it from home. However, if we as the employer direct the employee to work from home, whether express, imply it implicitly, it doesn't matter. We got bad news in both situations. Implied direction that the work needs to be done at home and that the employer knew and expected to be done there, well, we got a fact pattern here too. The employee was injured while driving home to translate depots. Sounds familiar? I think all of us have probably hired or worked with court reporters. The employer said, I need this work done urgently. That is, as in tomorrow. The court reporter required uninterrupted concentration, and that was not an option at the office to do because there were too many distractions going on after hours. So she had no option but to go home or elsewhere to do the work. And the District Court of Appeal said that is work related. And the reasoning was the employer expected this work to be done the following day and didn't provide a workplace and knew that it was going to be, she was going to go beyond the normal work hours, and knew she regularly took depots home for translation, but most importantly, approved the practice. Here's the difference. You might say, well, that sounds a lot like Wilson. Well, it's not. In Wilson, working from home was at the employee's convenience. It was not for the, it was not required implicitly, expressly, or contractually by the employer, versus Brahmo, this court reporter, where she had no other option but to work somewhere other than her place of business. And it was a normal, this was a normal case, or a normal fact pattern that was normally approved by the employer. Now, the fact that she worked from home and that was a normal practice approved by the employer probably alone would not have won the day for her, but that combined with the fact that the work could not be performed at work, that is the magic combination. All right, sit back, close your eyes, and just try to imagine this possible situation. There's a plague engulfing the earth, a virus, especially the US. It transmits from person to person through respiratory droplets. A government recommends and requires folks to work at home. Physical and psychiatric injuries occur while working from home. Are you able to imagine that? I think we can probably imagine that. We've got something going on. It's a little bit like that. Okay, folks are allowed to work at home. Injuries sustained while making a reasonable or reasonable. The word reasonable. The lawyers love the word reasonable because what you, the next guy, the next gal, and I, and more importantly, applicants, attorneys, defense attorneys, defendants, and judges determine is or are reasonable, is going to depend on person to person. It's going to change. So it's great work for attorneys arguing what is and is not reasonable. So they're allowed to, if an employee is allowed to work in an injury and the injury is sustained while making a reasonable or anticipated use of the premises, it's going to be compensable. The bad news. Don't worry, there'll be good news. So hold tight. Santa Clara case, fairly recent. This is a terrible case. You're just going to hate it. Working from home due to a non-industrial injury. So it's not our fault. In a wheelchair for non-industrial reasons. Not our fault. Gets injured transferring from the toilet to the wheelchair. Is this work related? Yes, they held. Yes. The employee was given permission to work at home as a reasonable accommodation. This falls under the category of no good act goes unpunished, I guess. Because this was approved by the employer, the home became the workplace, at least for workers' compensation purposes. They also said, you know what, defendant, you would also lose under the personal comfort doctrine. If an employee is using well, it's more typical at the place of business or the work site. But if they're using the bathroom or eating lunch in the lunchroom or what have you, but doing something that involves a personal comfort to them, but it's expected, reasonably expected, that's probably, and they're injured, that's probably going to be work related. The Gilman case, love this. This is a workers' compensation case. I'm not that, let me rephrase that. This is a workers' compensation attorney involved here. It kind of made big news when it happened in the industry. I hinted at this earlier. The attorney was carrying a box from home to her car. It was full of files. She had attended the hearing, left the Workers' Compensation Appeals Board that afternoon, and carried the box of files, of workers' comp files of work, into her apartment to finish her job. And then she carried the box back to her car the next day, and it twisted and broke, and she injured herself. She testified, I routinely did this. Everybody knew I did this. Heck, all the other attorneys do this. And actually, that's pretty much the case. I know I've done it, and I can't think of an attorney I know who hasn't done it in workers' compensation. She said she usually went home to review her work and dictate after her afternoon appearances. No reason to disbelieve that. So, is that work related? Is that work related? No. The holding was no. The reason being, she was not on a special mission. There was nothing extraordinary or non-routine about carrying a box of work documents, and there was no evidence, this is the most important one, that when she took the work home, it was to the benefit of the employer or for any, and that's sort of an aside. It's an argument that was made, but the one that really won the day was that it was for her convenience only. There was no advantage to the employer. And remember, what's the other part? It was not expressly, implicitly, or contractually required by the employer that she do the work from home. We mentioned the personal comfort doctrine. Let's go into that a little more detail. An injury on an employee's premises during the work hours often are compensable, even if performing an activity that is not a duty of the job. I'm going to call this the stupid doctrine. By that I mean if you're doing something at work that's not stupid, it's probably going to be work related. If you're doing something at work that's ridiculous or stupid, it's probably going to be found to be not work related. As I suggested earlier, using the bathroom, chatting with a co-employee. I don't know how you injure yourself that way, but apparently somebody did. Drinking a cup of coffee, as long as it's not laced with booze. Lighting a cigarette, as long as it's not in a no smoking area. Doodling on a pad of paper. These are all, by the way, these all come from cases, none of which I'm going to bore you with. All these represent the personal comfort examples of the personal comfort doctrine, and they are considered work related. This is interesting. It is not indispensable to recovery that at the time of the injury, the employee must be rendering service to his employer. It is not indispensable to recovery that at the time of the injury, the employee must be rendering service to the employer. I hear it from employers all the time. Well, I don't care why he was doing. I don't know why he was doing that. It didn't give me any benefit. That doesn't matter, and that's been the case since 1942. So I hate to deliver that bad news, but that's not going to work. Now, will I argue it? Absolutely. I'll toss in everything about the kitchen, everything including the kitchen sink, and I'll throw up everything against the wall. But we can't expect that to win the day. The employer need not benefit from the activity that the applicant was engaging in at the time of the injury. The Supreme Court has said this, and they said, quote, a strong nexus between the personal act and increased efficiency or other benefit to the employer is not a prerequisite to workers' compensation coverage. Personal convenience, acts of personal convenience are within the course of employment if they are reasonably contemplated by the employment. That is, if they're not stupid. I'll give you examples of stupid in short order. So here's the test: whether whether the act was reasonably contemplated by the employment and not stupid. The judge is going to take a look at the nature of the act itself, the nature of the employment. I mean, do they sort of make sense together? What everybody does in that job or occupation or in that particular industry. Terms of employment of the contract, and remember, you can have implied contracts as well. It doesn't have to be just in paper. And other factors. Once again, the full work employment verbiage for attorneys, just like the word reasonable. And now it doesn't go completely crazy. If they've got a complete departure from employment that could be considered a temporary abandonment, quote unquote, of the employment, that's not going to be considered a personal an act of personal convenience. So if they take a break, go down to the local brew hub, have a few beers, and slip and fall on a banana there, this is not going to be work related. On the other hand, if they go there with the supervisor, problematic. If it was at the supervisor's recommendation or suggestion, even more problematic. And if the supervisor is paying for it, just start paying the benefits. Now, it's important. The employer's knowledge of the activity in advance of its occurrence and the fact that there's no prohibition of it is not of any help. Notice this: no prohibition of it. This is why let's go back to the beginning of our presentation. We want to talk about having a list of duties that the applicant in equipment and locations that they're going to perform the work, and also a list of things that they're not supposed to do, shouldn't do, can't do, won't be approved of. We want an expressed list for that. We want to define their scope of work. We want that policy signed by them, stating things that are activities that are outside the description that are not going to be the employer's responsibility. You might say, well, I'm not sure if it's going to work in terms of workers' compensation. Well, you're never sure whether it's going to work in workers' compensation. I believe it will. Also, think of it as like the little ticket that you get when you park your car at a public parking place. It says, we are not responsible for any damage. Yeah, they are. If they do something unreasonable, they're totally responsible for the damage. But a lot of people don't file claims because, hey, they see a little ticket that says not responsible for damage. One more reason for us to have it in writing. It is scary. It's injuries sustained during acts of personal comfort that take place on the employer's premises are usually going to be compensable unless explicitly forbidden. So make sure you've got that list, you've got that agreement, and you've got that signature of the applicant that outlines what is expressly forbidden. What were the scary acts of personal comfort? Eating lunch, getting a drink of water, smoking tobacco were not permitted, attending to the wants of nature, going potty. You notice you're using the restroom or going to powder your nose in your 20s and 30s. But once you have kids, everybody's going potty. Changing to or from work clothes, pouring oil into a car engine while beginning to work, playing catch on the employer's lawn during a paid coffee break. These have all been deemed to be work related. What else? Get this. Now it gets even crazier. You'll understand why I think you should have this in writing. Jumping into a reservoir to rinse off after picking grapes. Guess what happened there? Getting treatment for an ingrown toenail. If you're an employer, I know you're just aghast right now. Chasing a picked lemon into the street when it rolled away. Not hard to guess what happened in that case. Chewing gum. How they injured themselves, I do not know, but they managed to do so. Using a curling iron. You can be responsible for something like that. or performing exercises at the desk, getting a flu shot, blowing their nose. Yes, there are situations where people have been known to blow out a disc in their back by blowing their nose or sneezing, and tapping an employee on the shoulder while passing. I recognize you can't list it. The list is inexhaustible, but don't give up the ship. Don't think that there's no point in developing a list, an agreement that's signed by the employee as to what is and is not appropriate on the job site or at home, because it's a good start, and you can cover most of the likely problems. Not all is lost. Some activities no reasonable employer would condone. In other words, they're stupid. What are those? What are some of those? What are they? Well, the judge is going to determine whether it's unusual, bizarre, daring, risky, or deviant. I always love the word deviant. It sounds like it's going to be far more interesting than it really is. Actually, hold on. There's one case that is pretty interesting. Or activities with inherent potential for injury to the employee or others. That reminds me of the joke. You know, who's the guy who says, if blah, 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 then you might be a redneck? My favorite of his is, if you have a relative who died shortly after saying, hey, y'all, watch this, you might be a redneck. Well, if you've got an employee who did something like that with inherent potential for injury and injured themselves, their potential personal comfort doctrine act argument is going to go the way of the dodo, and you should have a great defense. No personal doctrine where using a water slide, expressly prohibited from using it after hours. Drowning in an irrigation ditch while fleeing from immigration officials. Well, I'm glad to hear that. All right, here it is. I told you that where there was going to be a bizarre one. Death by asphyxiation while masturbating at work. Can you imagine the audacity of wanting to go to trial on such a case? I think I would just roll up, get into the fetal position and die if I had a spouse who had died this way. I don't think I'd be broadcasting it through a published case, but the wife nevertheless said, hey, there was a benefit to the employer. This released tension and stress and made my husband a better employee. They didn't buy that. They said, you know what? There are some things, well, let's just read it. There are still some personal acts which are best performed at home, or at least not on on the premises of one's employer. I think that's good advice. There's no personal comfort doctrine where the injured employee loaded a gun, brought a loaded gun to work and tested it. Mom performing personal errands, and these apply equally to home. So screwing up if you've got a secretary who's playing with guns, you've certainly got you don't have a work injury when they shoot themselves in the foot, literally or figuratively. Personal errands for the daughter or son or spouse, even on the employer's premises, that is at the home, are not going to be work related. Reason? Well, these truly are purely personal. The employer is getting nothing for it. So even though they're on the employer's premises or in the home, which is the place of business, that nevertheless does not mean it's work related. And this is oftentimes you'll have managers of apartment complexes who also, as part of their compensation, live in one of the apartments. And it's very difficult at times, due to the bunkhouse rule, to argue that it's not work related. But we do have cases where the manager is only acting as a tenant, not doing anything that's managerially related, and those have been found to be not work related. So, is there a new secret weapon out there? Maybe. Remember I said I like to throw everything up against the wall? This falls under that category. Virtually all the case law we've looked at is pre-2002. In 2002, there was a CCR that was adopted that did not have to do with workers' compensation, but that doesn't mean it's not interesting authority that shouldn't be made reference to when we argue a case down at the WCAB district office in front of the judge. This particular CCR was regarding employers' obligations to report injuries. So at least that's close to work that is work related and keep records. It's not the labor code, and no case law has done this, but there's enough overlap that I'm certainly going to make reference to this in my arguments. Anyway, it claims to define injuries that take place in the work environment that are work-related, and actually more expressly, that are not work-related. So, an injury of illness or illness occurring in the work environment that falls under one of the following exceptions is not work-related. The employee is at the work site, but as a member of the general public only. Now, they're going to argue they were doing something for the employer, but if we've got a policy that says you shall only work from 9 to 5, then that's when the gloves are going to come off. Involves signs or symptoms that surface from work, but only from a non-work related events or exposures that occur outside of the work. Very much like the law we just discussed. Voluntary participation in a wellness program, medical, fitness, or recreational activities such as blood donations, physical exams, flu shots, unless explicitly required by the employer. And I think we're going to see a lot, we're already starting to see a lot, and we'll continue to do so in our coronavirus world. Exercise classes. We talked about the providing exercise plans to keep people not only physically fit, but mentally fit at the beginning of this. Under this CCR, if they're injured, you're not highly unlikely you're going to require or demand that they engage in an exercise program, but encouraging it, just encouraging it, will not buy you a workers' compensation claim. Prior case law suggests otherwise, so I'm not saying this is a slam dunk, but it's well worth considering. Racquetball, baseball, I don't know how they came up with this, but that's our legislature. The injury or illness is the result of the employee eating or drinking. Now that's not on par. That does not agree with traditional workers' compensation law or lore. And so this is something we definitely want to consider. Preparing food or drink for personal consumption. Now, under the old case law, if you go to the lounge, employee lounge, and toss something in the microwave and slip on some water, it's going to be considered work-related. If you cut your hand with a knife when you're slicing up the sandwich, it's considered work-related. That is not true under the CCR anyway. Choking on a sandwich while the employer's in the employer's establishment is not considered work-related, according to the CCR anyway. If they're made ill, however, by ingesting food contaminated by the workplace, that would be considered work-related. That makes a lot of sense. Or if the employer provides the food and they're poisoned somehow, that would be work-related. And the give other specific examples. Doing a personal act that is outside their assigned work activities. This seems to conflict with the personal comfort doctrine. It certainly gives us a good argument. And there we go, personal grooming, personal comfort doctrine. Under old law, old case law, personal comfort doctrine would suggest that it's going to be work-related. Maybe not under the CCR. Again, I don't bet the farm on this, but it's something that we need to be able to throw up against the wall. Self-medication for non-work-related conditions. Okay, that would be in conflict with the old law and something we could consider. Or intentionally self-inflicted injuries. Well, that is one of the 36 Labor Code Section 3600 defenses that we regularly rely on. A motor vehicle accident that occurs in the company parking lot or a company access road while the employee is commuting to or from work, that is, according to the CCR, not work-related. Under old case law, it would be considered work-related. So they're expanding the going and coming rule here. Illness is the illness is a mental illness. The employee has to voluntarily provide the employer with the physicians or appropriately trained healthcare professional that says it's work-related. All right, good luck with these. Like I said, I don't bet the farm on them, but I will certainly throw them up against the wall anytime. Defending against bad habits. Though the job may contemplate tolerance for personal habits, Long-term effects are not considered work-related. We've got a case where a gentleman was smoking on the premises and at home for years, got bronchitis. In another case, somebody died. Both of the situations were not compensable. Personal comfort doctrine, be damned. If the condition is insidious, detrimental, systemic effects of a personal habit, solely under the control of and in the self-indulgence of the employee, which habit is neither required nor in furtherance of employment, it's not going to be work-related. However, here's what they're going to argue. Secondhand smoke, kind of obvious, but here's the more problematic. They're going to say, I wasn't smoking, or I wasn't smoking as much, and job stress made me do so. And that's what the courts say. The test of causation is satisfied that one can reasonably infer that but for the employment, the injured worker would not have contracted the disease. So actually, this is going to be very fact specific and definitely one for litigation. So general rule, individual acts of convenience are compensable, but cumulative effects of a personal habit are not. So what is it going to help us avoid? Successful claims for obesity, drinking alcohol or soda, which could be dangerous, sexual habits, good to know, anger management, consuming caffeine, the #1 drug of choice in the United States, consuming sugar, the #1 favorite substance of folks in the United States, that's why obesity is growing so greatly. But again, be careful if it was developed, the problem developed or was exhumed due to work stress or other work factor, it probably will be found to be work related. This is interesting. I love this case. We have a workers' compensation appeals board judge who said, I got a smoking injury. I got bronchitis, or I've got some kind of cancer, and I smoked, and it was work related. It was held it was not work related. The judge couldn't even win this one. So this is a habit, and this is the punchline. Your job isn't stressful. I dare you, I double dog dare you to go down to the board and tell a judge his or her work is not stressful, but that's what the court said. The Almond decision, alcoholism, said we had a problem here. The alcoholic said the work stress increased my alcohol consumption. This was a defense win, nevertheless, because it was, again, I said this wouldn't be fact dependent. It was demonstrated by the defendants, but that, no, you were drunk long before the job. You were drinking a lot then. You continue to drink a lot more now. That's not work related. Playing with weapons, similar. I'm going to skip ahead a little bit because we're going to run out of time here. Really important point. The defense has a secret weapon. It's called Labor Code Section 3600. Why is that such a secret weapon? It includes a whole lot of things. And this is not, it includes about 24 different defenses. Some of the big ones are the intoxication defense, intentionally inflicted injury defense, willful and deliberate suicide, initial physical aggressor, felony conviction rule, voluntary participation, post-term psych claims, et cetera, et cetera, et cetera. Like I say, there's at least a couple dozen of these. Why are they important here? Because you need to know them. If the personal comfort doctrine conflicts with these Labor Code Section 3600 defenses, the 3600 Labor Code Section 3600 defense wins the day. It trumps, and therefore we, the employer. By the way, I should have made this perfectly obvious. I'm a defense guy through and through. Have done labor law defense, employment law defense, workers' comp defense. So anytime I say I or we, I mean employers and carriers and TPAs and self-insured employers. I'm also an employer. So for that reason alone, I'm definitely on your side. Here's an interesting case. An injury was sustained as a result of an off-duty recreational, social, and athletic event because the applicant was playing basketball during a lunch hour. So you can imagine your home-based employee saying, I took a break because I was stressed out and I played some basketball, or I threw the ball around with the kids, or I took a jog around the neighborhood, or I did that and the other, but it made me a better employee. said I was more relaxed and I was better able to do the job. And I argued in the very beginning of this that there are a whole host of reasons that why the employer would want the employees to go out there and relax a little bit. It was unpaid, however, and the employer did not sponsor it. Was it personal comfort doctrine? Nope. It was not AOE COE. The Labor Code Section 3600 off-duty recreation defense won the day, and the employer won. All right, investigations of COVID and 19 and everything else. We are almost, how are we doing on time? We're going to make it. We're going to make it. Options, social media. Remember, okay, if they're working from home and they're injured, or they're allegedly injured anyway, always follow it. Also preface it with an allegation or alleged. First off, you're going to do an interview. They want to do an interview as quickly as possible before they get an applicant's attorney, because stories change. The day after the injury, the truth comes out. It's funny how the initial treatment records, when there's they go to the emergency room, often have a completely different story from the one that we hear in deposition 3 months later. So we want that investigation done right away. In addition to that, though, we've got social media options. And the great thing about social media options is they're free. If you're suspicious, first off, well, the private eye is not going to be free, but there are some PI things you can do on your own that are free. Do just a web search of the employee's name. If they've got an unusual name, that can be very helpful. If they got a date of birth, you can put that in as well. If you've got a phone number for them. I once had a case in which the employee had given the adjuster a phone number, and the adjuster gave me that phone number because she was unrepresented. The applicant was unrepresented. And then she called the adjuster the next day and said, "Oh, no, I don't want you to use that cell phone number. I want you to use this other cell phone number." Light bulb went up and went off, and I thought, why do people have more than one cell phone number? I'm sure there are legitimate reasons, and some of you probably have more than one. But there are a lot of illegitimate reasons I can think of too. So I typed that phone number into my computer, and up came a listing on Craigslist. Okay, no big deal. Maybe she's selling some sheets or some bottles or whatever. Well, she was selling something, or leasing it or renting. I don't know exactly what the legal term would be, but it involved her body. It was the adult services section, which was interesting. She was collecting temporary disability, claiming she couldn't work, and she was definitely a working girl. That case was resolved very quickly. So, oh, there we go. By the way, she included pictures, which was just a little interesting. So Bing, Google, Yahoo can definitely be your friend. Facebook. We want to be careful with Facebook. If they have a public Facebook, and a lot of them do, you'll find out that they've been on vacation, that they just went to Tahiti on vacation, and the person who claims that they're stuck at home all the time maybe isn't stuck at home all the time. But what if they have privacy settings? You want to reach out and see if you can friend them. No, you don't want to. Absolutely not. You are going to get in all sorts of trouble. There is case law directly on point. The experts recommend you don't. I may or may not be an expert. You have to judge that. But I recommend that you don't. Don Marshall, the chair of the California Fraud Assessment Commission, national director, said, and I quote, "It's inappropriate, if not illegal." No, it's illegal to secretly friend someone to get information. If someone does not with our firm, they will be thrown out. You can't friend someone and work your way into an area that they think is going to be private. You also can't lie to them in other ways. There's the famous Unruh case from 1972, in which a private investigator became a friend and actually started dating the applicant. At least, and well, pretended to be a friend and pretended to be a boyfriend. Took her to Disneyland, took her over to one of the, what do you call them? The bridges, the suspended bridges that are put together with wood and ropes, so they jiggle around. Got her out there, he got her in the middle of it to prove that she could handle a little jiggle. and a little physical force, he started shaking the bridge and had somebody over on the side videotaping it. The trucking insurance exchange got sued. The private eye got sued, and they lost big time. So don't be a false friend. Don't either online or in face-to-face. I know employers are often surprised that injuries at the premises are work-related, but you want to remind them, as we've done today. Just a rehash of the things that we went over at the beginning. Require express written authorization before the employee can work remotely, and get an authorization or a signed list of things that they can and cannot do for work. Update and maintain accurate job descriptions and expectations of what they can do and can't or should do and shouldn't do. Confirm that they understand their responsibilities while they're home. Specifically define their home office space. Provide training on workstation setups. Use safety checklists. And I know it's going to be expensive to send to somebody to go through to their home and go through a safety checklist, but that doesn't it doesn't mean you can't give the list to the employee, have them fill it out to determine whether or not there are safety problems, and sign that and return that to you. Have a written reminder of the obligation to promptly report all injuries, because you really do want them reported as promptly as possible. Why? Well, for selfish reasons. The sooner it's reported, the faster we can investigate it, and the more likely we can get the true story behind it. Remind them who should receive any reports of injury. Don't want them to be able to say, I didn't know how to do it. The employer wouldn't tell me. Require all employees, exempt and non-exempt, to provide include detailed records of actual time worked. Like I say, if you have the punch, the best possible option is the punch card equivalent online, so that when they go to their computer to go on, they punch and say, I'm now working, and when I'm done or taking a break, I punch out. Detailed records of meal breaks and personal breaks. Well, that is. We went over 4 minutes, and I want to apologize profusely. I hope this was of value. Please feel free to email me or give me a call if you have any questions, concerns, what have you. Definitely contact Tammy if you'd like one of these beautiful masks. And I'm going to pass it on over to Tammy. Tammy?
Thank you, Don. And thank you, Kimberly and Sophia, for answering questions throughout the presentation. And thank you all for attending and submitting those questions. We appreciate it.